Hi, my name is Jim Gordon of Beers & Gordon.
Hi, I'm David Beers, Beers & Gordon, here today to chat briefly about determining fault in a car crash and how important it is in the work we do to represent victims of car accidents.
It depends on the type of accident. If it's a rear-end accident and you're the person that got rear-ended, there's a very good chance they're at fault. Almost all rear-end accidents are the fault of the driver that's in the rear. There might be another issue, who had the light. Sometimes there's an issue about red lights. And you may think you have the green light, you think the other person had the red light. One of the ways you can determine who's at fault in that is there's potentially red light cameras at that intersection. It's something we will look into. If you hire us at Beers & Gordon, we know where to go to find those red light cameras. We've certainly seen red light camera videos that's helped our clients significantly. I remember one in particular that helped my client not only to prove that he wasn't at fault for the accident, but it showed the severity of the impact. It actually showed my client's vehicle tire rolling away after the impact. And it was a pretty significant video that we could show in that. So that's another way to determine fault.
In representing victims of car crashes, we frequently encounter the situation where the other driver, the person that we intend to make a claim against, is disputing their fault for the crash. So in regards to how that is done to represent our client, we typically, of course, do rely upon the crash report and the information contained in it. We also look at Google Earth photographs and attempt to reconstruct the accident as best we can using our experience of over 66 years of doing these types of cases. And we also look at obtaining statements, witness statements, if we can, from people who are identified as witnesses to the crash. There's other more sophisticated technology that we use quite frequently today in serious crashes, one of which is the so-called prevalence of electronic data recorders in vehicles manufactured particularly after 2012.
Sometimes no one knows, and you just don't know who caused the accident. Someone says, I pulled out, I didn't see you, and you were going too fast, and you might be the person that's being alleged to go too fast. We can look into that at Beers & Gordon. We've been doing this between us almost 70 years, and we can look into those facts because there's information we can pull. For example, we can pull information off what's called the EDR, which is electronic data recorder off a vehicle to tell you how fast it was going just before impact. That could help prove who was at fault, because if we could prove that even if you're the vehicle that pulled out, the other vehicle was going 80 and a 45, that's going to prove fault. So there's many ways we can look into it. We can talk to other experts, accident reconstruction experts, human factors experts, biomechanical experts that can help us determine who's at fault in an accident. How do you determine who's at fault in an accident? That's a very important question. It's sometimes the most important question in the case is who was at fault for causing the accident. It depends on the type of accident. Obviously, if it's a rear-end accident, it's almost always presumed that the person that rear-ended the person is at fault. If it's an issue about who had the light, it depends on who had the light and if it was a green bulb versus a green arrow, different things like that. So you got to look at the specific facts of the accident and determining who's at fault. Make sure you report that to your insurance company. Your insurance company needs to know that you were at fault in the accident because you want to make sure they're going to defend you, and pay for those damages to the other vehicle and the injuries to the other party. The important thing is if you're sued in that same crash, you may want to talk to an attorney. You may want to call us at Beers & Gordon and say, I've been sued, I was at fault for the accident, because you may want what's called a hammer letter written. A hammer letter is essentially a letter to your insurance company telling them, please settle the lawsuit within the policy limits, because you, as the insured, have no right to tell the insurance company what to do. The insurance policy says they get to do what they want in terms of settling your cases. So you want to make sure you come to us, you call us and say, hey, would you help me write this letter? I was at fault for the accident, but I'm worried my insurance coverage is not enough. I want to be protected against what's called an excess verdict, a verdict which would be essentially against you individually.
If you are seriously injured in an automobile accident and it is determined by the investigating officer that you are at fault, that should not deny you the opportunity for recovery in Florida. So, and again, discussing the potential for recovery for very serious injuries of some of our clients, we do look at, obviously, at the fault issues, but even where the fault may be as much as 50% yours for causing a collision, you still have the opportunity to recover for your damages because of the application of Florida's pure comparative negligence principles of law. And of course, part of what we do, based on our experience, is we negotiate and discuss the various factors involved in a collision to attempt to change that percentage of fault from, say, 50% by you to maybe even 25% of you. And if you've been seriously injured, that 25% may make a big difference to what you can recover.
There are times where even if it's your fault for an accident, there might be a lawsuit involved. I know that sounds probably odd to most people as they say, well, if I caused the accident, why can I sue someone? Let me give you an example. You have an accident, and unfortunately it's a rollover accident, maybe your fault, but you have severe injuries from the accident, and you find out that the vehicle wasn't manufactured correctly. We've seen product liability cases where the vehicle wasn't properly molded in the manufacturing process. They missed rivets, something like that. And there's a products liability case for what's called crashworthiness. So even if you're at fault for an accident, there are potentially other avenues of recovery, especially in a serious accident on a products liability issue, because you may have caused the accident, but the problem is rollovers, for example, there has to be crashworthiness, there has to be, that type of thing. So there can be a tie-on products liability case, even if you're at fault for an accident. And something that the more serious the accident, the more often you want to look for that and talk to an attorney about that.
Many times we're asked whether you should admit fault in a car accident. It's a very humane feeling of all of us that when bad events occur, you wish to take whatever accountability and responsibility that you may have. And frequently we encounter clients who have made statements at accident scenes to police officers and others acknowledging that they had somehow caused the crash. When in reality, we've been able to learn, again based on our 66 years of experience, that the mechanics of the accident, using mechanical engineering principles and time and distance analysis, the actions of our driver, our victim, our patient, our client, is not the cause of the accident.
And I've seen that in cases where, one case in particular, where there's an intersection and the intersection actually changed as you went through. You had to jog to the right a little bit, and my client thought, I don't think I'm at fault, but I might have been. I turned left. Well, it turned out the other person we found out they were texting and driving, and they weren't looking up, and they ran right into my client.
And so it is not a good idea to concede fault for a collision to an investigating officer. Certainly be respectful, certainly answer all their questions. You're required to by law. You must cooperate in giving them information, but you're not required to admit fault. And so it's best to simply acknowledge, I'm sorry the accident occurred, and that you are obviously going to be injured and not in a frame of mind to really give a careful analysis to how the accident happened. And this is the best way to proceed, both with the police authorities and frankly with your own insurance company.
The question is, who pays for a no-fault accident? And a no-fault accident is really more of no one can determine who's at fault. And an example would be two people both claim they have the light, there's no witnesses. Both people, you hit in the middle of the intersection, one person says, I have the green light, the other one says, I have the green light, and you're coming from opposite directions. And the officer throws up his hands and says, I can't figure out who it was, I wasn't here. So what do you do about that? A couple things. Number one, you can look into, in that case, you might look into red light cameras or other surveillance nearby that will help prove your case. And there's other ways to prove something like that, whether it's accident reconstruction, something like that. If you can't prove that case, if you can't prove or you don't think an attorney, and that's why you want to have an attorney look at that type of thing, and call us at Beers and Gordon, we can look into those things. We have experts. We've been doing this so long, we can a lot of times look at the case and say this is how we could or could not prove if you were at fault in that accident or the other driver was at fault in that accident. If it's purely you can't determine or you don't know and they don't know and no one can determine, then basically what happens in that type of no fault accident is your insurance company pays for your damage, their insurance company pays for their damage. Potentially, if you're injured, your insurance company may pay for your injuries as well.
Florida's no-fault law is designed to pay for the immediate needs of the injured parties through their own insurance companies. And so, if there is no permanent injury sustained by our client, then no fault will pay our client's medical expenses up to $10,000. Now, personal injury protection benefits pay 80%, so there is a 20% gap from the so-called PIP-approved billing that is not covered by medical expenses under PIP. So you need to purchase a voluntary type of coverage, which is called medical payments coverage, which all insurance companies offer, and there's a very small premium for that, and that picks up that 20% gap so that 100% of your first $10,000 of bills would be payable by your own insurance company.